Oyez, oyez, oyez. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and you shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Good morning. Welcome to today's session of court. We have a couple of cases to hand down this morning. Civil 19-786 in the matter of the estate of Robert H. Slaughter, deceased, Garland Trice Jr. versus O.East Trice and O.C. Trice from the Lee County Circuit Court. Reversed and dismissed. Court of Appeals opinion vacated. Justice Womack dissents. See, Justice Wood, did you have a case?
Yes. Ms. Pechtold, could you read the submission?
Absolutely, Your Honor. I'd be happy to. On behalf of Justice Rhonda Wood this morning, the court is handing down criminal case 21-118, Howard Togo Wood Jr. versus the state of Arkansas. This is an appeal from Scott County Circuit Court. It is affirmed in part, reversed and remanded in part. Justice Womack concurs without opinion, and Justice Webb dissents.
Okay, thank you. And will the clerk please read today's submissions?
There are 10 appeals being submitted to the court this morning, the first of which will be our oral argument, Civil Case 20-713, and Jenkins versus Mercy Hospital Rogers. This is an appeal from Benton Circuit Court. Criminal Case 21-148, Stanley Warner versus the state of Arkansas from Van Buren Circuit. Criminal Case 21-154, John Drennan versus the state from Hot Springs Circuit. Civil Case 20-363 in the matter of the estate of John Harold Haverstick from Woodruff Circuit. Civil Case 21-233, James Pavito versus the Game and Fish Commission for the state of Arkansas and others from Pulaski Circuit. Civil Case 21-279, Jennifer Rivera Sarin on behalf of herself and others similarly situated versus Presidential Limousine and Auto Sales from Garland Circuit. We have criminal case 20-284, LaJason J. Coakley versus the state from Miller Circuit. Criminal 20-513, David Edward McLaughlin versus the state from Garland Circuit. Civil case 21-147, Jackie L. Williams versus Dexter Payne as the director of the Department of Correction, an appeal from Jefferson Circuit. And the 10th appeal being submitted this morning is civil case 21-313, Tarek Nooner versus Ray Hobbs and James Gibson from Pulaski Circuit. In addition to those 10 appeals, the court is also receiving submission of 18 other various motions and petitions. All of today's decisions and the submissions are available on the court's website.
Okay, thank you. Let me mention that Justice Baker is not present for the Zoom of the oral argument, but she will view the live stream on YouTube. Our case for oral argument today is Civil 20-713, Jenkins versus Mercy Hospital Rogers. And the court will recognize the appellant's attorney for their argument.
Thank you, Chief Justice Kent, and may it please the court. I'm Matt Kazaya, appearing on behalf of the appellant. Your Honors, this is a case about religious freedom. We believe so strongly in religious freedom in this country that we've passed statutes that actually restrict the right of contract with employers to terminate whoever they want. They cannot discriminate, importantly for our purposes today, on the basis of religion. Well, Mercy did that. Mercy says we do not religiously discriminate, and yet when it came to giving Anne her flu shot exemption, they picked and choose among who is acceptable. This is not okay. It causes 3 causes of action that I want to talk about today. I'm going to take them in reverse order of the briefing because they are in reverse order of complexity. Starting with the ACRA, the most complex, Your Honors, this case is easily brought down to a single maxim. Your right to swing your arms ends just where the other man's nose begins. This court in Coode versus State addressed the same point. A person's right to exhibit religious freedom ceases where it overlaps and transgresses upon the rights of others. Organizations who do not act like a church are not treated like a church. Mercy says that they're a religious organization, but in our third amendment complaint, and actually prior ones as well, we said that they are not, in fact, a religious organization. And the court has addressed that very point in Alamo. If you don't act like a church, you're not treated like one. In all objective regards, Mercy is indistinguishable from its secular competitors. It operates in the secular world of medicine. It claims tax exempt status. They only get to pick one. They choose hospital, not church.
Counselor,
Yes, Your Honor.
isn't the exemption inaccurate? Isn't it the language in it very broad in terms of defining when it applies?
Your Honor, I think you're asking about the religious organization exemption. The religious organization exemption is not actually defined. It says if they are a religious organization, then the ACRA does not apply. We take issue with whether they are a religious organization to begin with. These two cases, Coode versus State and Tony and Susan Alamo Foundation, are the basis for our objection. Basically, they say if you're not acting like a church, you're not treated like one.
And what findings did the trial court make in that regard?
Zero, Your Honor. They made no findings. We were dismissed at the motion to dismiss at the complaint stage. So we asserted findings of facts, which is what I was addressing here, that essentially they're not distinguishable from their secular competitors. But the court made no findings of facts. There are no findings of facts to be made at complaint stage.
What did the court find in regard to the exemption?
In regard to the exemption, it found that Mercy is a religious organization because it says it is. And the problem with that is, as we briefed below, affiliation is not enough. And there's a Ninth Circuit case directly on point. Affiliation is not enough. You must act like a church to be treated like one, at least under Title VII purposes. Title VII, which of course ACRA was modeled after, originally it was created for churches, not third-party secular institutions that are just affiliated with a church.
However, the circuit court did make a finding in regard to judicial estoppel, didn't it?
Yes, it did, Your Honor. Yes. So there's a problem with judicial estoppel. To start, there's a four-pronged test for judicial estoppel. Indisputably, we raised at the first complaint stage, we conceded they are a religious organization. That is very different from our second amended complaint and third, which says they are not a religious organization. That satisfies prong one. The rest of the prongs are not there. The second element is intent. Why did I revoke that concession? Well, the reason is that it was out of ignorance, basically.
So it was not to manipulate the system or with malfeasance.
Definitely not. No, Your Honor. And in fact, we actually moved for an extension of time after the first motion to dismiss. On the second motion to dismiss, when we filed the second amended complaint, there was a 1 month extension that I asked for so that I could research all of this process. And there was a timeliness issue that I want to emphasize here. From the right to sue letter to being able to file in federal court, you only have 90 days. I don't remember exactly when Ann Jenkins came to see me, but it was sometime during this 90-day process. I only had about a month to file the complaint. I didn't have time to look into what does it mean to be a religious organization. I just took them at face value when they said we're a Catholic organization. I just took it at face value. Why not? But as I dug deeper into it, I found this Doug Laycock article and I found these two cases. I said, well, maybe there's something more to this. Maybe there is something that I can fight about here. And I think that we have a meritorious case.
So because you were at the stage of a motion to dismiss, you didn't put on any evidence, affidavits, or anything to allow the court to make a factual finding in that regard.
Correct. Yes, Your Honor. This is basic legal standard stuff. The complaint is true because it says so. We assert that it's not distinguishable, and Mercy, their time to contest any of these assertions is through the discovery process and possibly in a motion for summary judgment. But not at the motion to dismiss stage. There are two other points that I wanted to address on the judicial estoppel grounds. One, I never argued that Mercy is a religious organization. That's important. That's prong number 3. Prong number 4 is systemic integrity preserved? Yes, an amended complaint nullifies the prior complaints. If Mercy doesn't like the new allegations, it's as if I never filed the original complaint to begin with. They just go about the normal discovery process. That's their remedy here.
Counselor, what about collateral estoppel and the fact that in your federal proceeding that the federal court found that Mercy was a religious organization?
Your Honor, that's a very good question. Thank you for asking it. Collateral estoppel absolutely has no basis here. So collateral estoppel, to address the point further, you need to have a final judgment on the merits. That's what you need, a final judgment on the merits. I pleaded a case, and I cited it, and I want to say the reply brief. I made it very clear this is a narrow construction issue of, can Title VII religious organization exemption be waived? That is the question. That is the only question that was posed by my complaint. And the federal court answered no. And once the answer is no, that disposes of it. So collateral estoppel, there was no fact finding. There was no judgment that says Mercy is a religious organization. What the judge did is answered a narrowly defined question. That narrowly defined question is no longer before this court, because now I'm taking issue that Mercy is not a religious organization. Once you don't have that contest of fact, that's where collateral estoppel comes in. You need to have the contest of fact. You need to have a full trial process, or minimally some kind of motion to dismiss, a motion for summary judgment. It has to be on the merits. This was not on the merits.
Thank you.
Which actually conveniently brings me to the next point, which is waiver. Unlike in federal court and unlike in Title VII, Arkansas statutory exemptions can be waived. And we cited the Academy Inc. versus Paradigm Building case. You can absolutely, waiver occurs when one with the full knowledge of material facts does something that's inconsistent with the right or his intention to rely upon that right. That's an appellate case. This court on Smith versus Walt Bennett Ford has explicitly upheld waiver of a statutory exemption. So how do we know that Mercy waived its right to religiously discriminate? They published an EEOC policy that says we won't. That's how we know they waived their right. During the course of the employment process, Ann Jenkins was allowed to celebrate Sabbath on Saturday. Catholics celebrated on Sunday. Muslims were able to wear hijabs. Ann Jenkins was allowed to modify her employment outfit with tassels, religious tassels. Everyone at all times said, yes, you are free to have religious accommodations. It wasn't until at some point it became inconvenient to Mercy that they got rid of that.
Counselor, let me go back to your complaints if I could. So in federal court and the original complaint that was filed in circuit court, your client conceded that Mercy was a religious organization. And then when you amended, I think the third complaint, she alleges that it's not a religious organization, but she said it was affiliated with a religious organization. So help me understand the difference between your allegation that was affiliated to a religious organization as opposed to it being a religious organization.
So affiliation, Your Honor, is when someone has some kind of an official relationship with someone else. You can be affiliates, but that doesn't necessarily mean that you're owned by or you're in the same organizational capacity. You don't do the same things as the other organization. This is the Kamehameha case that I pointed out. This is 990 Federal 2nd 458. That's a Ninth Circuit case, to be clear, but the Eighth Circuit hasn't opined.
So how is Mercy affiliated with the Catholic Church?
I take the understanding that they are because they say they are. It could well be for our purposes that they're in fact not affiliated with the Catholic Church. I think that is a possible fact out there, but I basically I'm taking them at face value. And after this business with are they a religious organization to begin with, I probably shouldn't be, but it's Rule 11 says I can only argue things in a complaint that I can prove. If I can't prove it, I'm not putting in a complaint. So I take a very narrow strategic decision to just, if I can't prove it, if I don't have the facts right now, if it's not coming from my client's mouth, I'm not putting it in there, or publicly available documents. Like,
Would it have been better for that not to be included in that complaint?
possibly, Your Honor, but at the same time, if it's going to be dismissed at summary judgment stage, I'd rather not waste my time with depositions and discovery and whatnot. If the trial judge is going to kick me out because they're an affiliate, I'd rather get that out on the front and then resolve that on appeal. It's our position that affiliation is not enough. And in fact, the Tony and Susan Alamo Foundation, that was an organization that said they're a church. And this very court said, no, you're not a church because you're not acting like one. So if you're not treated like a church because you're not acting like a church, I don't see how logically you can be treated like a church just because you're affiliated with a church by contract or otherwise. Affiliation is not enough. You have to act like a church. Mercy does not act like a church. That's all there is to it. They're not a religious organization. However, I concede it is conceivable that this court might find that they are a religious organization, in which case we have an Establishment Clause problem. The ACRA says, and this is important because Title VII, I want to draw the distinction. Title VII in California are a good case study for what is constitutionally not just permissible, but I think mandated. Religious organizations cannot be regulated when it comes to their ministers. And in fact, U.S. Supreme Court just came out with a case in 2020 that says so. There's a free exercise right. I'm a church. I get to choose who my ministers are. Ministers are people who officiate the religion. They're the faith leaders. They're the ones who teach it. That is a very, very sensitive and important thing for churches to be able to control. Otherwise, you might have a minister out there, and I use the term minister in the terms of the cases. This could apply to any clergy member, whether Christian, non-Christian, atheist, you name it. Clergy just means clergy. In any event, you might have someone who's preaching the wrong faith. And we can't have that as a church, obviously. It's a free exercise right to do what we say is right. So that is the free exercise bare minimum. You cannot go below that. That's why Title VII allows religious organizations to either hire people who are only of their own religious faith. Mercy doesn't do that. They don't even have trustees of their own faith. And you can do whatever you want with your clergy persons. So those are the two critical points. That's Title VII in California. Contrast, Washington, just like our case, our statute said, religious organizations can do whatever they want. You want to fire someone because of their race? Have at it. You want to fire someone because of their sex? Have at it. Religion too, but those other two are the issue. Once you go overbroad, once you go beyond the free exercise threshold, you run into a different problem, which is an Establishment Clause problem. Now what the state has done is given a free market advantage to religious organizations that is not giving to secular organizations. And I'd cite the court to, there are three significant Supreme Court cases. That's the estate of Thornton versus Caldor, Texas Monthly Inc. versus Bullock, and Corporation of Presiding Bishops, basically the Mormons versus Amos. Those are the three United States Supreme Court cases that bear on this Establishment Clause problem. But I can make it a lot easier by just pointing to two cases that are the compare and contrast for our statute. We have California, that's the Pizak case that I cited in the reply brief, 112 Fed Sup 2nd 970 versus Ochiltree. Ochiltree is the Washington case that says if you're not a minister, then this business of religious organizations can do whatever they want. That's fine only if the employee is a minister. Anne was not a minister. She was a physical therapist assistant. She did not officiate ceremony. She did not teach the religion. She helped people with their physical injuries. She's not a minister. That is why the ACRA would be unconstitutional, both federally and under Arkansas state grounds.
Counselor, let me ask just quickly, you mentioned earlier that Mercy had waived its right to claim the religious affiliation, but don't we have a Sixth Circuit case that the opposing brief cited, Hall versus Baptist Memorial Healthcare, that specifically found that a religious employer could not waive the religious exemption by representing that it was an equal opportunity employer?
Yes, Your Honor, and I could do you one better. There's a bunch of cases that say so for purposes of Title VII. That's why this ACRA case is meaningfully different. Title VII in federal law says one thing. But Arkansas common law in the process of construing this particular statute, I don't see how we can resolve how you can. There's a bunch of cases, I believe I cited them, if not in the chief brief, then below, bunch of cases where statutory exemptions have been waived. So I don't see how you can resolve those two for purposes of Arkansas law. That might be true for federal law, but not for our law.
Thank you.
Thank you, Your Honor.
Court will recognize the appellee. And you're still on mute.
Very sorry about that. Good morning. May it please the court. I'm Gary Martz here for the appellee, Mercy Hospital Rogers. I want to start by addressing the arguments that my colleague made on the other side about the Arkansas Civil Rights Act and the religious organization exemption. And I think the place to really start with this is it goes back to a question that Justice Hudson asked, which is, isn't this exception a broad one? And looking at the language in the statute, it is a broad exception. It's Arkansas Code annotated 16-123-103A, and it says the provisions of this subchapter relating to employment, so all of the provisions of the Arkansas Civil Rights Act relating to employment shall not be applicable with respect to employment by a religious corporation, association, society, or other religious entity. So it doesn't say churches, and it doesn't really restrict the reach of that to a particular kind of religious entity or organization. It's any religious entity. And so in this case, what we have is, we discussed earlier the doctrine of inconsistent positions, we've discussed judicial estoppel, but what we have is we don't even have to get to those doctrines, because repeatedly in this case, including in the operative complaint that was dismissed, Ms. Jenkins alleged that Mercy is affiliated with the Catholic Church. And affiliation with the Catholic Church makes it a religious entity under the terms of the statute. It's fairly plain. And if you look at it, it's not just loose language in the complaint either that Ms. Jenkins included, well, it's an affiliation with the Catholic Church. It wasn't a throwaway line. It's made in the context of her allegation that she believed Mercy would do what it said because it's a religious entity, because it's affiliated with the Catholic Church. It's a substantial factual allegation. It's not a throwaway line. And that's all that's necessary, is that she has alleged in her complaint, and an allegation that is taken as true because this case was decided on a motion to dismiss, that Mercy is affiliated with the Catholic Church, and therefore under the statute, it is exempt from the reach of ACRA's employment provisions.
Counselor, do you think that there's a possibility that the circuit court cut this off prematurely in terms of allowing Jenkins to put on some evidence, bring in some affidavits or documents to be specific about how Mercy is acting in relation to this affiliation? That maybe we haven't had an opportunity to fully understand the lay of the land.
I don't believe that the circuit court cut the case off too quickly, Your Honor. It's important to put the complaint that was dismissed into its context. This was the 5th time that Ms. Jenkins tried to plead this claim, starting with her complaint in federal court, where she said Mercy is a religious organization. Where that complaint was dismissed on the federal ground, the federal claim, because of that allegation. And then she had an opportunity to plead her state claims in circuit court. She did it again. She said it's an affiliate of the Catholic Church. She pleaded, we move to dismiss. Here comes another complaint. Same allegation. Move to dismiss again. Here's the 3rd state court complaint. Same allegation. Move to dismiss that one. Now we have a 4th state court complaint. Same allegation. And I don't think that there's anything that needs further factual elucidation or development. Ms. Jenkins alleged in her complaint that Mercy was affiliated with the Catholic Church and therefore is a religious organization. There's not a reasonable inference. I'm sorry, did I cut somebody?
Yeah. Let me ask you this. So you heard the opposing counsel explain that there was a difference in his third or fourth amended complaint, and that that they allege it's not a religious organization, and the word affiliation had no significant meaning other than it was just a term. But she alleged that it was not a religious organization. Period. And so he explained there was a difference in what you're saying now. And of course, that was a question I asked him. And so you could have an affiliation with anything and not necessarily act like that entity. And I think that's what he was trying to explain. So what is the purpose of the appellant's third or fourth amended complaint when they allege it's not a religious organization?
Well, as for the purpose of that amended complaint, I think that the purpose of the attempt to amend the complaint was a realization that the claim was not going to work as pleaded. The original strategy from the terms of the complaint was to try to evade the exemption by claiming that it was waived. And then I think that strategy appeared to be one that was not going to work. So there was this new attempt to try to say something different. But I think that, there are a lot of conclusions in the complaint about Mercy not being actually a religious organization. But again, there is a factual allegation in the complaint that it is affiliated with the Catholic Church, and that is sufficient to make it a religious entity for the purposes of this statute. I think if we want to get into those allegations, the other allegations that are made in the later complaints, I think that there is a problem with the fact that those allegations contradict allegations that have been made throughout the case. This court has made.
Counselor, wouldn't you also agree that there are no facts that were presented, by either party to the court that it was not, Mercy is not a religious organization? Any facts to that effect?
I don't think so, Your Honor. There were the allegations were things like operating a hospital is not a religious purpose. And I think that would be news to a lot of hospitals in the state of Arkansas that are affiliated with religious organizations and carry out that work as a means of carrying out their religious work.
So how can this court make a determination as to whether it was a religious organization when the circuit court had no facts either way before it to make a determination that it was religious or not, other than the term that was in the third amended complaint that it was affiliated with the Catholic Church?
Well, I think, Your Honor, this was decided on a motion to dismiss. So I think the first thing the court has to do is determine what the statute means, what the statute requires. And that takes that broad exemption and determines what is required to fall under that. And then I think the court has to look at the complaint, the operative complaint, and determine whether there are facts alleged in that complaint, taken as true, as the court must do for a motion to dismiss, that would establish that Mercy does not fit the definition or does not fit the terms of the statute. And I think my position on that would be that the allegations in the complaint don't suffice. There's, trying to say that running a hospital is not a religious purpose. I don't think that needs further factual unpacking. If the court takes that allegation as true, the court has to determine whether that would take a religious affiliated hospital outside the reach of the statute.
So, counsel, outside of the allegation made by the appellant in this case and the complaint, can you give us just, very, very briefly, the nutshell version of what that affiliation is with the Catholic Church?
What the affiliation is that Mercy Health is, and I'll say that I don't have a detailed understanding of the relationship. But Mercy Health is affiliated with the Catholic Church, as is alleged in the complaint.
Is there a formal relationship that you're aware of, or is it just, hey, we claim to be part of it?
So it's a formal relationship with an arm of the Catholic Church.
Okay, so let me ask, how would this case be different if this was a purely secular hospital? The Siloam Springs Regional that was mentioned in the brief, for even not a hospital, say XYZ Manufacturing Corporation. How is this a different case than what you have now in that scenario?
It's a different case under the Arkansas Civil Rights Act because there's not a provision in the Arkansas Civil Rights Act exempting secular organizations. The reach of the act, as the General Assembly drafted it and put it together, is to prohibit certain forms of employment discrimination, but to not apply that prohibition to religious corporations, associations, societies, or other religious entities. So if this was not a Catholic hospital, if it was a different kind of hospital that was not affiliated with a religious organization, we wouldn't be discussing that exemption.
Okay. And so I know we're dealing with the flu shot here, and I know there's maybe not as much attention on that as there has been, for instance, to the COVID vaccine. And are you familiar with Act 1115 that was just passed by the legislature this last month?
I'm afraid I'm not, Your Honor.
Okay. So if you're not familiar, I won't go too deeply into it, but they specifically addressed as the public policy of the state dealing with employer mandates as they relate to the COVID vaccine. There is some generic legislation that may on the surface apply broader than that, but I know there's some element of a public policy argument here, and I just didn't know if you were familiar with that in respect to what the legislature has stated is the policy of the state versus what they have in this particular set of circumstances. So thank you.
I like I said, I don't know the act, but I can, based on what you described there, I don't think that affects the reach of the Arkansas Civil Rights Act, because the issue here is not the particular act that was done, not the alleged act of discrimination. It's broader than that, in that the Arkansas Civil Rights Act does not reach religious organizations. Now, there is a public policy argument made in this case in the context of a wrongful termination claim. And, obviously an act that was just enacted last month was not in effect in 2018. Mercy could not have acted in accordance with it if it applied here at all.
Counsel,
yes.
The public policy argument alleged fraud. Is that correct? Not a public policy regarding vaccinations?
That is correct. The allegation in the complaint was that Ms. Jenkins was trying to put her claim within the exception to the at-will employment doctrine for violations of public policy. She did not identify a public policy of the state of Arkansas from its statutory law or from its constitutional law. She identified I'll get to that. She identified a public policy generally standing against fraud. And then when pushed on the issue of identifying a statute, she identified the theft of services statute. And the theft of services statute has absolutely no application here. There's no allegation that Ms. Jenkins worked at Mercy and was never paid. There's just simply nothing of that nature in this case. The court has been clear when applying that exception to the at-will employment doctrine that the public policy issue has to be express, it has to be explicit, it has to be clear on its face as applying to the facts of the case. And the court has not allowed public policy exception claims when there is some sort of attempt to imply it from general principles. There's the Palmer versus Arkansas Council on Education, Economic Education case from about 20 years ago, where the argument the plaintiff made in that case was that this entity was commingling state and private funds in the same bank account, and that is contrary to sort of general principles of financial accountability. And what the court said is there's not a statute in effect that prohibits that practice. And because there's not, you can't bring your claim within the scope of the public policy exception to the at-will employment doctrine. And that's what we have here. Ms. Jenkins hasn't identified a specific statute that prohibits anything that she alleges Mercy did. She's identified she first identified fraud. She tried to say that the public policy can come from the common law as opposed to statutory law, which is not something this court has ever allowed. And then when pressed on the issue of a statute, she identified the theft of services statute, which simply does not apply. There is no allegation in this case that Mercy stole anything from Ms. Jenkins or that it took her labor without pay or anything of that nature. So it just simply doesn't apply. And there's never been in this case a public policy identified that applies to this circumstance. Moving on to other issues in the case, there is also another attempt to sort of shoehorn this case into another exception of the at-will employment doctrine, which is the policy for the exception for situations where an employer makes a guarantee of continued employment or a guarantee of job security or guarantee of how things are going to work when people are laid off. And there's simply nothing of that nature alleged in this case. The allegation of what is supposed to be a guarantee is the fact that Mercy made generalized statements about the fact that it would not discriminate in employment decisions. But there's no guarantee of continued employment. And the flu shot policy that's at issue specifically says to all employees that this is a condition of employment and that if you don't get the flu shot or get an exception to it, you will be terminated. So that was told to her from the start. That's the policy at issue. And it doesn't guarantee any sort of an exception either. It says that you may apply for an exception. And it also very clearly accounts for the fact that an exception might be denied. Because it says, if you make an exception request and that request is denied, you can appeal. But it never guarantees an exception just simply because somebody makes a submission. It is always discretionary with Mercy as to whether they will grant that exception. That's what the policy says. We just don't have a situation in this case like the ones where the court has found a statement in a handbook or an employment policy that creates an exception to at-will employment. It's just not the same thing. It's not like the cases like, Crane Industries, I think is really the key case in Arkansas on this issue, where the employer had a handbook and it said, if we lay people off, we're going to lay them off on a last hired, first fired basis. And the court said, once you made that guarantee, you had to honor it. We just don't have anything like that in this case. And so that's why the circuit court dismissed that claim and did so properly.
Counselor, let me interrupt you real quick. And out of curiosity, how is Mercy defining what a sincerely held religious belief is?
I do not know the answer to that question, Your Honor. I do not know what, I have not had the opportunity to do any investigation into how that decision is made. I take it that a committee of people takes that application for an exception, considers it, and makes the determination.
How would Ms. Jenkins know what that is? She would have to look at the policy. I suppose that she could have asked questions of people at Mercy before she made her request for an exception. I think probably to some degree in that circumstance, what is a sincerely held religious belief is probably in the eye of the beholder. And I think that kind of takes us
Counselor,
back. Yes.
didn't opposing counsel just talk about the fact that Ms. Jenkins was allowed to wear certain regalia in connection with her religious beliefs at work?
He did say that.
And so does that seem a little inconsistent that on one day she gets to wear things that reflect a possibly sincere, genuine religious belief, and then when she exercises it in a different setting and for a different purpose, that it is denied by Mercy?
I don't think it's inconsistent, Your Honor, because I think there's a substantial, important difference between what somebody wears to work on a day-to-day basis And
But
somebody,
isn't that a reflection of a genuine religious, sincerely held belief that if you were going to don items that identify you with your religion, that it's likely a sincere effort?
well, I think, yes, I assume that if somebody wears something that they believe to reflect their religion, that that is a sincere thing. But I think there's a categorical difference between somebody's garb that they wear on a day-to-day basis, which may or not be clear what it signifies to somebody outside of that religious group, and a policy that applies. The flu shot policy is not in place for some purpose of, just bothering employees. It's a policy that's in place because it's a hospital and the hospital wants to stop the spread of flu at the hospital. And that being the case, then they take this a little more seriously. And there's a requirement that there be a
But
request.
still, it's either a sincerely held belief or it's not.
Well, but I don't believe that there was not a policy in place for seeking leave to wear certain kinds of garb on the
And as
job.
Justice Wynn was pointing out, like, what is the analysis? How does an employee know how this is going to roll out in one context of what I can wear versus another context of what's injected into me? We don't, based upon the record, I don't see that we know that information, and I don't hear you offering it today either.
Well, this case was decided on a motion to dismiss, restricted to what's alleged.
And is that a problem?
I don't believe
Because
that
we
it
got
is.
cut off at a motion to dismiss without further information factually to define this universe.
I don't believe that it is, Your Honor, because I frankly don't believe that the allegations or the claims about what was worn, I don't think it fits any of the claims here. I think it was maybe offered in the context of a waiver of the exemption under the Arkansas Civil Rights Act. Our position is that that's not waivable. It defines the scope of the act, and there's no waiver involved. You can't waive, whether it's through the adoption of a policy or whether it's through allowing people to wear a certain piece of religious regalia. That does not waive the exemption, because the exemption is defining the reach of the act. And so I don't think that that's a problem for deciding this case on a motion to dismiss. I think it's simply, that's a fact. I don't think it's a material or relevant fact to the claims that have been alleged in this case. I don't think it changes the outcome of any of these claims. If Mercy is exempt from ACRA, it's simply, there is no delving into how it handles these religious claims, how it handles, attempts to get exemptions or exceptions to the flu shot policy.
So that leads me to the fraud claim that
Okay.
Jenkins says. I mean, for instance, there was some sort of a poster or something, even at the hospital, that talked about them being a non-discriminatory employment or employer, and that she relied on that in accepting this employment. And as she got into the employment, at some points, Mercy is sensitive to her genuine religious connection by allowing her to don this regalia, but then later kind of switches horses midstream and doesn't allow her to exercise that same religious connection to her health.
I think that sort of recitation of the facts compresses them considerably from what is actually alleged in the complaint. What is alleged in the complaint is that Ms. Jenkins was hired in 2012. She had no issue with the flu shot policy at the time.
How do you
Applied
know?
to her. I'm sorry?
How do we know that?
How do we know that? Because she said it in her complaint. There's an exhibit 3 to her complaint on page 27 of the record. It's her application for an exception. And she says that I haven't had an issue with the flu shot policy, but my views have changed. And so the first time she asked for an exemption from the flu shot policy is in 2018, 6 years after she was first hired. And so there's no way that Mercy could have known in making these generalized statements about workplaces or anything, the specific issue that was going to arise. It couldn't have known, one, that 6 years later, Ms. Jenkins would have a change of heart and decide that she could no longer get a flu shot. Nor could Mercy have known what it would do with that information once presented to it. And in that case, there's simply not fraud under those circumstances. There was never any sort of representation of fact made to Ms. Jenkins about what would happen when she sought an exception to the flu shot policy. There was an attempt in the briefing to try to make this case like Interstate Free Services versus Hauser, a 1992 case. That this
Thank you,
court
Mr. Marks. You've answered my question.
Okay, thank you, ma'am.
And let's see, now that you've answered those questions, are there any other questions? Okay, your time's expired, so thank you, Mr. Mark.
Thank you.
And the court will take up rebuttal for the appellant.
Thank you, Your Honor, and may it please the court. I want to start with this false dichotomy that there's a categorical difference between garb and the flu shot. There isn't. All of the things that Ann was doing in the course of the employment that we address in this complaint is related to, it derives from her belief structure. She feels the need to wear her tassels. She needs accommodations for her work schedule so that she can celebrate Sabbath on Saturday rather than Sunday. I forget the rest of them. She wants to celebrate Passover, so she needs time off for that. All of these things derive from her faith structure. Did she get deeper in her faith structure over time? Absolutely, yes. I don't see how that's a problem. I don't see how Mercy needs to foresee what Ann particularly needs to do during the hiring process. That's not what their policies say. That's not what the EEOC poster says. What Mercy says is we will not religiously discriminate. That's it. So for Ann, it is a question of her faith for her, whether she takes the flu shot or not. For her, in her sincerely held religious beliefs, it is an act of blasphemy. She doesn't eat pork either. Can Mercy force feed her pork as a condition of her employment? Under opposing counsel's argument, the answer is yes, absolutely we can, because at the time she got hired, she ate pork, presumably. That's not okay. The question was posed earlier, how does Mercy make the determination whether Ann is sincere or not? There's nothing in that policy that says who makes the determination of whether they are sincere or not. But here's how we know, as the questions posed pointed out correctly, she needed all these accommodations for her faith, and that wasn't a problem before. So that's pretty good evidence that Ann was sincere in her beliefs. Number two, during this whole process of this contention of whether she's going to take the flu shot or get fired, she talks to the hospital's chaplain. The hospital's chaplain tells her, thank you for sharing something so important and sacred to you. This is in the complaint. Third, she'd rather get fired than take the flu shot. She would rather suffer grievous financial harm than take the flu shot. That is compelling evidence that Ann is sincere in her belief structure. They knew she was sincere. They just chose not to bless her with equal treatment under their policies as all of the other hundreds of people that they talked about during the EEOC proceedings. Other people get this flu shot. That's beyond a doubt. It's just that Ann doesn't get that benefit. Why? Why? That is the question of this case. And we never got to pose these questions to anyone at Mercy because we got kicked out at the complaint stage. I want to address this theft of services argument as well. Mercy lied about the deal. That's what it is. Mercy knew we do not actually adhere to these policies that say we do not religiously discriminate. They knew it. They've been defending their right to religiously discriminate since at least 2006 and didn't start working there until apparently 2012. That was the deal. We will not religiously discriminate, and accepted employment there because she was worried that they would religiously discriminate against her, and they said they won't. She rejected alternative employment at a secular hospital where she could have sued them for Title VII if this exact same thing happened there. She rejected it. Why? Because Mercy says we're not going to religiously discriminate against you, and they treated her the same as everyone else until they didn't. That's fraud. They lied about the deal. The other set of questions posed were, what facts are there about whether Mercy is a religious organization? I respectfully disagree that the sole fact of relevance is affiliation. The question under Pre-existing case law is how do they act? What do they do? They sell medical services. 99% of their revenue comes not from charitable contributions like a church does, but from selling the secular service that is medicine. They're not laying on hands, they're selling services, medical services. We compare and contrast it against both Washington Regional and Siloam Springs to show this is indistinguishable from their secular competitors. That's it. That's the most important one. What else do we know? They're not staffed exclusively by Catholics. They don't do mass. They don't have Catholic priests in their employ, and they're not even run by Catholics. They're board of trustees, the very same EEO policy that says we're not going to religiously discriminate against Anne. We're also not going to religiously discriminate against who runs the show. That's how we know they're not a religious organization. The sole predicate for their claim is that they have some kind of a contract, some kind of co-marketing deal with the Catholic Church. That's not enough.
Were those facts before the circuit court?
Yes, Your Honor. All of those facts that I just addressed, I cited them at page 32 of my opening brief. All of these are in the...
It was in the brief, but it wasn't in an affidavit.
Not in an affidavit. No, Your Honor. We don't need an affidavit. Rule 11 says so. The facts of the complaint are deemed true, period.
But were they pled in the complaint?
Yes, Your Honor. Yes. And again, the direct citations to the complaint are at page 32 of my opening brief for everything that I just said.
Okay, thank you. I see that your time has expired. Are there any questions? Okay, thank you, counselors.
Thank you, Your Honors.
That'll conclude our oral argument today. Court will be in recess for 15 minutes when we take up the case conference, and as to these proceedings will be adjourned. Thank you.
Thank you.